Hi everyone, hope you're doing well. Karthik sir here. Today we are going to see the revision of chapter number 6, that is registration of charges. Okay, let's start with it immediately. Let's see this. First, we have section number 77, that is called duty to register charges. Any company which is creating a charge basically means what? Company must have taken money either from debenture holders or from any lender, and the company is giving some asset as security. Giving any asset as security itself is called as creating a charge. So whenever a company creates a charge, at that time the company has to get the charge registered with the ROC. So what does the law say regarding this? They say here in this way: whenever the company creates any charge, whether the charge is created in India or outside India, or any property, asset, or undertaking which is located in India or outside India, the company has to get the charge registered with the ROC. Now, here you have to see that whether the charge is created before the commencement of the company amendment ordinance, that is nothing but 2nd of November 2018. So you have to see, is the creation of charge before that, that is whether the loan is taken and the security is given before that or after that. So if the charge is created before commencement of the company's amendment ordinance 2019, in that case the company has to get the charge registered within 30 days from the date of creation of charge. If they have not registered the charge within 30 days, then they get 300 days again, but 300 days is calculated from date of creation of charge. They can pay additional fees and get the charge registered within this 300 days. And still, if the charge is not registered, they have said whenever the company's amendment ordinance has commenced, from that day within 6 months, you can get the charge registered with the ROC. However, if the charge creation is on or after the company amendment ordinance creation, company amendment ordinance commencement, that is nothing but 2/11/2018. If the charge is created on or after this date, then in that case they have said the company has to get the charge registered within 30 days. If they don't get the charge registered within 30 days, they should get the charge registered within 60 days from the date of creation of charge by paying some additional fees. And if they still don't register within these 60 days, then they get further 60 days. That is, after the initial 60 days are over, further 60 days by paying something called as ad valorem fees. Comfortable? Second, they have given in this same section that whenever the company is getting the charge registered, there has to be someone who is verifying something in relation to the charge. So there should be someone who is verifying that the asset is actually in existence, and they should verify that yes, the charge is there. If the company is situated outside India, sorry, if the asset is situated outside India, okay, in that case, any one of these five persons can get the charge verified, and that is first any the seal of the company, the hand of the director, the hand of the company secretary, any authorized officer of the charge holder, or any person who is interested in the mortgage, okay, or the mortgage or in relation to the charge that has been created. If the asset is situated outside India. However, if the asset is situated in India, then you have to, instead of these 5% and 3%. What was this one first? This was the seal of the company. Hand of the director, hand of the charge holder. Then you have in this, the ring finger will be the authorized officer of the charge holder. And then you have, sorry, hand of the director, hand of the company secretary, authorized officer of the charge holder. And this is basically a person who is interested in the mortgage or property in relation to the charge. This is for outside India. But if it comes to, when it comes to in India, you will just say these three persons. So these three persons, okay, they have to verify the charge. Comfortable? The liquidator of the company will not consider the charge to be registered unless the charge is actually registered with the ROC and the certificate of registration of charge is available. Only then the liquidator will consider that the charge is actually registered. Whether the charge is registered or not registered, the obligation of the company to pay the loan liability, that is the installments of the loan, that is the principal plus interest of the loan, to the bank will always be there. The company cannot say that just because the charge is not registered, we will not pay the liability of the loan. The company cannot say that. That is your section number 77. What is section number 78? Section number 78 goes in this way. If the company has taken a loan and company has given any asset as security, the company has to get the charge registered with the ROC as per what we saw in 77. But if the company fails to get the charge registered, in that case, the bank, or we can say the charge holder, can itself get the charge registered with the ROC by filling form CHG1 in the case of other than debenture holders. And if debenture holders are the persons who have given the money to the company and they have taken the asset from the company, then the debenture holders will fill form CHG9. And this they will give it to the ROC along with the fees. The ROC will give notice to notice to the company saying that, see, the charge holder has given the application in form CHG1 or form CHG9. The company has to do what? The company has to ensure that a company is getting the charge itself registered, or saying to the ROC that, giving sufficient reasons to the ROC saying that why the charge should not be registered. And if the company remains silent during this matter, basically the company within this 14 days does not give any reply. So if the company does not give any reply, then you understand that the ROC can get the charge registered. Get the charge registered. So within 14 days, if the company does not give any reply, the ROC will get the charge registered. For creation of for giving the certification of registration of charge, ROC will give form form CHG2, and in the case of modification of charge, ROC will give form CHG3. Now the CHG2 and CHG3 will be issued to the company and will also be issued to the person in favor of whom the charge is created. It will act as a conclusive evidence. The liquidator will only consider that the charge is registered only if the charge is registered. And finally, the same point which I told earlier in 77, that whether the charge is registered or not, it does not absolve the companies of its responsibilities for paying the loan amount. Company has to fulfill its obligation of paying the loan amount. Simple. If the charge holder has paid the fees to the ROC, then the charge holder can get the fees reimbursed from the company, because actually it was a duty of the company to get the charge registered. Simple to understand this area? Okay. That is basically this part. That is the section number 78. What is section number 79? Section 79 says section number 77 to apply on certain matters. And they have given two matters there. Matter number one is when any person or any other, or when any organization, any other company purchases the property that is already subject to a charge. In that case, they have to also follow section number 77. That is, they have to also get the charge registered with the ROC. Second point says whenever there is any modification in relation to any charge, they have to get the charge registered with the ROC. That is simply what they have given. Then in the class, I also made you all do the modification. We saw some examples of modification we had seen. Change in the rate of interest, change in the duration of the loan, is extension the company is getting from the bank. All this will be the modification to the charge, and that also the company has to inform the ROC. This comes under section number 79, that is section number 77 to apply under certain matters, that is 79. Comfortable? Next is section number 80, date of notice of charge. Now what does this section say? Any person who is dealing with the company and dealing with the asset which is subject to a charge is deemed to have notice of such charge. So any outsider who is dealing with the company, that outsider has to go through the register of charge, and he should know that which asset, again, which asset has been given as a security, against which asset the charge has been created. That person should know, the outsider should know. If the outsider doesn't know, it will not be the company's fault, it will be the outsider's fault. That is what section number 80 says. It is similar to what you did constructive notice when you did, that is doctrine of constructive notice, when you did law in CA foundation. That is your section number 80. 81 not there. 82, let's go further. 82 is what? Company to report satisfaction of charge. Whenever the company has paid the loan amount or the charge is satisfied in some way between the company and the bank, company has to inform the ROC, intimate the ROC, inform CHG4, and that is your intimation of satisfaction of charge. If the company fails to do that in 30 days, company has to do that within 300 days. Whenever ROC gets this intimation in CHG4, ROC will give a show cause notice to the charge holder. Charge holder can be the bank or debenture holders, whoever it is. So ROC will give the charge holder a show cause notice, and they will write in the show cause notice in this way. They will say, show us the cause why the charge should not be considered to be satisfied within 14 days. So within 14 days, you show us the cause why the charge should not be satisfied, should not be taken as satisfied. If the bank or the debenture holders give a reply to the ROC, then the ROC will make a note in the register of charges and inform the company. And if the bank or the debenture holders don't give any reply, ROC will patiently wait for 14 days. And after 14 days, if no reply is received, ROC will consider that the charge is satisfied. And the ROC will mention that in the register of charges and then inform the company. That is your section number 82. It is also possible in this way that the company has gone to the charge holder and taken the signature of the charge holder, and then the company has gone to the ROC with the intimation in form CHG4. In that case, ROC need not communicate with the charge holder because the charge holder has already given their signature or in the intimation of satisfaction of charge that they are okay and they agree that the charge is satisfied. Simple. Okay. Let's go to the next section, that is section number 83. 83 is third party to inform the ROC regarding satisfaction of charge. Whenever the registrar gets any kind of evidence from any third party that the debt has been paid or satisfied in whole or in part, or the property or the asset or any undertaking of the company has been released from the charge, or it is now ceased to form part of the company's assets. In that case, the ROC, after looking at the evidence, can put the entry in the register of charges that yes, the charge is satisfied. Charge is satisfied. And the ROC will, after putting the entry in the register of charges, inform the company and inform the charge holder. Inform the company and inform the charge holder. That is your section number 83. 84 is appointment of receiver or manager. Whenever by order or by an agreement, the company and the bank appoint any receiver or manager. So whenever the receiver or manager is appointed, the receiver or manager has to intimate to the company and to the ROC that he has been appointed. Whenever he is ceasing to hold his position, in that case also he has to inform the company and the ROC that he is ceasing to hold position. That is basically your appointment of receiver or manager. That is your 84. 85 not there. 86. Penalty is given. So penalty you can just go through in that if the person knowingly informs the ROC and knowingly does a default, willfully commits any crime. In that case, they are given there is a penalty for fraud, that is section number 447. But you can go through the penalty area. Next is section number 87, that is rectification by CG. If the charge creation, charge modification, or charge satisfaction is not informed to the ROC within the time given. So the time given matter is omitted by the company. The company did not inform the ROC. Or the particulars given to the ROC are misstated, or the particulars are not given only at all. Omission in giving the particulars, or even if the particulars are given to the ROC, submitted to the ROC, it is misstated. Whether the company does not follow the time or the company does not provide the particulars to the ROC, whether it is not done because of some genuine mistake or because of inadvertence or because sufficient cause is shown, whatever it is, the company can fill a form and give it to the CG and request the CG to rectify this error of the company. CG, if it is of the opinion that it is just and equitable, that it is okay, it is fair to give company another chance, the CG can grant extension in relation to the time which I told you, or CG can grant the company to allow the company any rectification in any kind of particular. CG will pass an order in this regard. The company will go and give this order, file the what you call the creation of charge, modification of charge, or satisfaction of charge with the ROC along with the order given by CG and along with whatever fees are required. The company will go and now inform the ROC, and the ROC will now get the charge register or modify the charge or make the entry for satisfaction of charge because the company is now approaching the ROC after giving improper particulars or after the time has completed, it is compulsory that after taking the CG's order only they can go and inform the ROC. Comfortable? That is your section number 87. That completes your entire revision of registration of charges. Very simple chapter. Okay, easy questions have come. I have uploaded a separate video on YouTube in relation to the question and answer for registration of charges. That is ICS past examination questions have been covered. You can check out that video as well. If you want me to continue these kind of videos, please mention in the comment section. If you like such videos, please like it, share it with your friends so that they are also benefited from it. Also, any other series that you want me to cover, please mention in the comment section below, and I will ensure that as and when I get time, I am going to upload those videos on YouTube. I wish you all the very best. Study well. Take care.